Okay, we should be live.
All right, thank you, Catherine. So I got it at 6:03 p.m. Judge Avery, if you, by roll call, I've been taking as we've gone along here, so we do
Okay, we
have a
should be live.
quorum. All right, thank you, Catherine. So I got it at sorry, I had YouTube open, so that was my fault. I apologize for the echo
That's
there.
okay. That's all right. That's all right. Well, thank you very much. Judge Brett Wilson is unable to join us in the meeting tonight, so I will assume the role of leading the meeting. We are here just for the sole I know that you issued an agenda, but we really are just here for the sole purpose of reviewing the legislation, which, okay, I actually don't have it. I think it's 763.
763.
763.
Well, one business item, Judge Avery, is if we could just approve the minutes from the February 7th meeting,
Oh, okay. All right. Thank you.
and then we can get into the review of Senate Bill 763.
All righty. Well, has everybody had a chance to review the minutes that were sent out from the February 7th meeting? Does anyone have a motion? Okay.
Motion to approve. Second.
Okay. Anyone opposed to accepting the minutes? Okay, I'm having a little trouble with my screen. Bear with me 1 second, please. Okay, thank you. All right. Anyone opposed to accepting the minutes? All right. So accepted.
Great, thank you.
So David, if you don't mind, if you could just present the bill as it's written, just highlighting the
Right.
points that affect the Sentencing Commission.
Absolutely. So just as we met a few weeks ago regarding the Judicial Transparency Act, the purpose of this call again is to review Senate Bill 763. The legislation will affect the operations of the Sentencing Commission, and therefore pursuant to the policy that this commission adopted in July 2019, for any legislation that directly affects the operations of the commission or sentencing guidelines, we arranged a meeting for the purpose of soliciting feedback and to request a vote on whether the commission will support, oppose, or take no position on the proposed legislation. So let me start with a brief review of Senate Bill 763 and discuss the impact on the commission. So Senate Bill 763 would require the Administrative Office of the Courts, with the cooperation of each state's attorney, to collect and provide to the Sentencing Commission approximately 75 data points for each case prosecuted. So just for example, to give you an illustration of the data points that are included, some of these are, but not limited to, the case number, the defendant's race, gender, and disability status, if any, the incident date, the arrest date, the district or neighborhood of arrest, the primary arresting agency, the charges listed on the arresting agency's paperwork. If applicable, the reason the state's attorneys declined to prosecute the arrest, the charges brought by the state's attorney, the prosecutor who brought the charge, whether the defendant was eligible for court-appointed counsel, and the proceeding where the determination was made, the arraignment date, the charge modification date, whether diversion was offered, whether the charge carries a mandatory minimum sentence, the prosecutor's recommendation on bail or bond, whether bail or bond was imposed, release conditions, if any, information on whether a risk assessment or other algorithm-based or quantitative tool was used in determining whether pretrial release was ordered or the amount of bail or bond, whether a plea was offered, whether a time limit was provided with a plea offer, all the terms of the plea offered, whether the plea was accepted or rejected, whether discovery was offered to the defendant before the plea, the date discovery was disclosed to the defense or defendant, the presiding judge at the pretrial stage, the case disposition, the presiding judge at disposition, the disposition date, the sentence type, the sentence length, the presiding judge at sentencing, supervision terms, services required or provided, if any, and forfeiture of property required, if any. So I just wanted to give you kind of an illustration of the breadth of information that is required by this bill to be collected. Now, the proposed legislation would also require the administrative office of the courts to record and maintain information for at least 10 years. The proposed legislation would require each state's attorneys to cooperate with the administrative office of the courts to provide the data necessary to meet the requirements of the proposed legislation. Senate Bill 763 would also require each state's attorneys to make publicly available certain information regarding the state's attorney's policies and practices by publishing information on the state's attorney's website and providing the information to any person who requests the information directly from the state's attorney. Now, with respect to the role of the Sentencing Commission, that really starts at on page 15 at line 15 under new statute, Criminal Procedure Article 15-505. Senate Bill 763 would require the commission to determine the way the administrative office of the courts provides certain information to the commission. It would also require the commission, in coordination with the AOC, to ensure the disclosure of information under the proposed legislation is performed in a uniform and consistent manner. It would require the commission to determine an implementation schedule and plan by which the AOC will disclose the collected information. And the implementation schedule and plan may include implementation on a rolling basis that starts by prioritizing a subset of the data collected, or that prioritizes disclosure from larger states' attorneys' offices first. Senate Bill 763 would require the AOC on or before October 1, 2023 to begin disclosing data stripped of any individualized or identifying personal information about any person arrested or prosecuted to the commission for the immediately preceding calendar year. By May 2024 and annually thereafter, the commission would begin publishing online the data collected related to prosecutions in a modern, open, electronic format that is machine readable, machine searchable, and readily accessible to the public on the Sentencing Commission's website. By September 1, 2024, the commission must report on the data received from the state's attorneys, comparing and contrasting the practices and trends among jurisdictions. Although I'll note it's not specified what practices and trends are expected to be analyzed in that component. Additionally, at least twice per year, the Sentencing Commission would publish issue-specific reports that provide in-depth analysis of one or more areas of prosecutorial decision-making, and at least one report must focus on racial disparities. The proposed legislation would also require the commission to determine an implementation schedule and plan by which the AOC will disclose the collected information on or before October 1, 2025. To note, with the staff thinks the dates in the bills may be off, the implementation plan and schedule by which the AOC would be required to disclose the data are due by October 1, 2025, yet we're to begin receiving data by October 1, 2023. I don't know if those were potentially reversed, but that's something that could be addressed later on if it moves forward. So in terms of the impact, like operationally and fiscally on the Sentencing Commission, for multiple reasons, the proposed legislation would have a significant fiscal and operational impact on the commission. So to comply with this legislation, the commission would need to create and host a database capable of storing extensive information for an estimated 750,000 prosecutions per year. So that's the first major impact on the work on the commission, as it would substantially expand the number of cases tracked by the Sentencing Commission, and would expand the scope of the commission's work beyond criminal sentencing to include all prosecution charging decisions, practices, etc. The estimated 750,000 prosecutions per year is based on the number of circuit court criminal filings, district court criminal filings, and motor vehicle filings for fiscal year 2019, which was the last full year before COVID, which we thought was the most appropriate comparison point. The Sentencing Commission's data currently is limited to guidelines eligible sentencings, which includes mostly original convictions and sentencings in the state's circuit courts. So Senate Bill 763 would expand the universe of data to all prosecutions, which is substantially larger. So for comparison, in fiscal year 2019, the commission received data for just over 11,000 guidelines eligible sentencings. So that's in comparison to what we're estimating is 750,000 prosecutions per year. So a substantial increase, obviously. The second major impact, the commission would need to create a tool for the commission's website, and we'd need to develop an application or program to publish data in the way they described it, which is this modern open electronic format that is machine readable, machine searchable, and readily accessible on the commission's website. The estimated cost for the development of the website application and acquisition costs, data hosting services, and purchasing of additional equipment for storing the data is approximate, and also the hiring, of a data administrator / IT system programmer is approximately $265,000 in year one and $155,000 per subsequent year, plus any incremental increases for service costs, increases, and salary adjustments. So just to put that in perspective, the Sentencing Commission's current fiscal year budget is $573,117. So the one-year estimate would represent approximately 46% of our current budget, our current fiscal year budget. A final point to note about the legislation is that it will require the commission to publish data that identifies individual judges and individual prosecutors. As outlined on page 11, line 8, the AOC is to disclose any data stripped of any individual or identifying personal information about any person arrested or prosecuted. However, the legislation does not indicate that judge information, specifically pretrial bail judge, disposition judge, and sentencing judge, or prosecutor information shall be de-identified. Accordingly, the legislation would necessitate a change in the commission's policy regarding publishing of data by individual judge. So that in essence is a similar component of the legislation we recently reviewed with the Judicial Transparency Act. In conclusion, just want to let everyone know that the hearing for this legislation for Senate Bill 763 is set in the Senate Judicial Proceedings Committee. It is scheduled for Tuesday, March 1st. I did see today that the bill is now cross-filed on the House side. It wasn't until I think possibly today. The last time I checked, it was not cross-filed. But I think because it was lately cross-filed, it's not assigned to the House Judiciary Committee. It goes directly to the Rules and Nominations Committee. And so I'm not sure there would be a hearing on the House side. Maybe one of our legislative members could address that. So as previously noted, the commission may choose to approve, oppose, or take no option. The commission could submit written testimony for informational purposes only. That is an approach that is sometimes taken by agencies with respect to legislation that affects their operations. I think at a minimum, it may be helpful if the commission notes that the legislation cannot be implemented by the commission unless appropriate funding is included. So that concludes my report, and I'm happy to address any questions, and obviously I want to open it up for discussion at this time.
All right. Well,
so
let's.
JB, I see Delegate Moon has his hand up. I don't know if you can see
Okay.
that.
Well, I cannot see that, so I'm
Okay.
going to ask you to go ahead and respond to the hands up.
Sure. Delegate Moon, did you want to go ahead?
Sure. Thank you, everybody. In holding with custom, if there's some sort of policy vote, I am likely to abstain, since again, this may come before us, and I do want to have the benefit of a public hearing and the discussion with colleagues that ensues from that. You had, Mr. Soleil, flagged correctly that it's unclear if we'll ever get one because the House cross-file came in late, so it's going to be in the Rules Committee, and so I guess it'll be up to the leadership whether to pull it out for a hearing. Otherwise, the only way we'll get it is if the Senate chooses to advance it, and that sort of gets to my first question, which is I'm really curious about the genesis of this bill, and thinking I may never hear at a hearing unless it's moving, but I surmise it's related to that other bill you mentioned. And the last time we talked about that, I think I had described it as a targeted or weaponized transparency bill. And so when I look at what's being proposed here and potentially reading between the lines, I wonder if this is intended to be somehow the opposite, like, all right, if we're going to do transparency, let's blow the doors open. Here are the 75 data points, as you suggest, that would be interesting. And then let's do a deeper dive into the data with analysis so that we actually understand this better. And I say, well, okay, I have to tell you at first blush, I don't hate all aspects of that concept. And so, the policy wonk in me is interested in some of those data points. And so I would just be curious, for the benefit of my knowledge, if funding were aplenty and, there was much to be done here, whether folks would be opposed to it. And I understand there's concerns specifically about the question about identifying information to specific judges. And, we could even pull that aside as a separate piece of this, but I am curious as to the whole rest of it, whether it's inherently offensive, again, assuming funds are there.
I appreciate that, Delegate Moon. I wish, it's unfortunate because Senator Sidnor was supposed to be able to participate this evening, and he's stuck in another hearing right now. So I wish he was able to be here to answer your question about the genesis of the bill, because I can't speak for him. I see Judge Avery with her hand up. Go ahead, Judge Avery.
Okay, so also, I'm sorry, Delegate Moon, I can't speak to the genesis of it either, but I will say that the judiciary is opposed to this bill as well, but the judiciary is not opposed to all of these data points either. I mean, we don't hate data. We're not against data. And a lot of this is important information. So there's no argument there, I think, from anyone. I think the real concern here is, number one, the judiciary data system is incapable of producing a lot of this data. And for purposes of this meeting tonight, I think that the really huge overriding problem for the Sentencing Commission is that this is such an enormous lift. It's such an enormous amount of data that is being required to be collected and analyzed by the Maryland Sentencing Commission. And it's just this so far exceeds the mission and the enabling legislation that creates the Maryland Sentencing Commission. And I think that it is what I would call an example of the adage that no good deed goes unpunished. So I think that in some ways this is a tribute to the very sound analysis and data collection and nonpartisan approach to data that is taken by the Maryland Sentencing Commission staff. And because they do such a good job, there are people who want them to do all of the jobs and collect all of the data and analyze it for prosecutors and judges and every aspect of the criminal justice system. And unfortunately, that's just it. That is my main problem with this bill, is that this task does not belong with the Maryland Sentencing Commission, and it exceeds the scope of the mission. So anyway, I'm saying that to you, Delegate Moon, because I also agree with you that I don't hate the ask on a lot of these data points, but the execution of this particular bill would be, I think, quite disastrous. That's all I have.
I don't know if anyone else had any input that they wanted to share or questions to ask.
Dr. Slay, I just have a quick question. You mentioned, among the many heavy lifts that would be required would, deal with IT issues concerning a database to process the 750,000 cases and
Right.
software in which to publish them on the website. I assume for information to provide for the fiscal note, you also, estimated, what additional staffing would be needed to, accommodate, such a huge change.
Right.
Can you share, just how many additional people that you would think that the commission would need to even begin to tackle this problem?
Right. I mean, a lot of the issues is database related and software related, Mr. Zimmer. I think it's a fair question. In our fiscal note, we did ask for one additional full-time database administrator / IT network person, someone who has both data administration capabilities and also can do programming capabilities in order to help us, to be able to publish the information on our website. So we did ask for one. I mean, in our fiscal note, we said it would require one fiscal note person, but really a lot of the other requests are about having the ability to host the app, to host the data. There's costs associated with that. It's not something that, we don't have the infrastructure in place to be able to do that. So we would need to outsource that to be able to do that. So a lot of it is more the costs associated around that, and then hiring one person, one full-time person to help us do what we would need to do on our end.
Yeah. And I would also think, since it requires 2 reports a year, that would also require, additional
Right.
staff.
Right. Rick, I think I see your hand up.
When I read the bill, what jumped in my mind as a daily practitioner is what sort of impact this would have on our day-to-day dealings among defense attorneys and prosecutors. And we're looking at it as data points and information to plug into a computer, and maybe ultimately that's what it would provide. But in getting to those data points, the impact on daily criminal defense practice from both sides of the aisle would be just, I think, incalculable. I can imagine, prosecutors having to, jot down and plug into every day into a computer program every conversation they have with a defense attorney about any modification of a plea agreement from any specific case. I might negotiate a plea agreement and there might be 3 or 4 or 5 different backs and forth. So now this prosecutor is entering every single chain to the plea agreement. And that's just one of the data points.
Right.
I can't imagine what would be required, and I can't, the impact of this,
No.
as it's written, is quite beyond what I think is reasonable or rational. There was a little mini discussion among members of the Maryland Criminal Defense Attorney Association of discussing, like Judge Avery says, some of these points are very interesting and would be useful to know. Perhaps, rewriting and adjusting some of the areas that would be, the data that would be sought from some of the specific points, and making something more practical that might have some ability to actually be provided in a way that's practical and would not impact on day-to-day criminal justice, in the courts. So anyway, that's what I'm hearing about this bill from the defense side.
Yeah, I would be interested. It's too bad that we don't have Mr. Harvey on the call, because I'm wondering what the reaction is of the state's attorney. So this same legislation was introduced last year. It didn't come to our attention because last year it didn't require the Sentencing Commission to collect, publish, and do the analyses. Instead, it had GoCap doing it, or the current name for GoCap. And so I didn't particularly know it existed last year, because it wasn't something that came to our attention. But it was basically the same bill, and then rewritten to have the Sentencing Commission, the AOC, to collect the data with the collaboration of the state's attorneys. I mean, I think I know from reading the statements last year that obviously, like the state's attorney's offices all said, it would require a substantial lift to be able to provide the information that was being asked. Alethea, did you have a thought?
Yeah, I was just kind of going to go off of what Mr. Finchie said and also respond to what you were just saying. I do work in the state's attorney's office, and some of my colleagues are familiar, and they said it would be a very heavy lift and it would require a lot fiscally. We just don't have the people to handle the data. Though I'm like others, I'm curious about some of the data points. You know, maybe if we do take a smaller chunk, but in reference to, you know, kind of, it sounded the same as the last bill. It was easier for me as a non-practitioner to see kind of the outcome or the reasoning for the other bill. I'm not sure, like, once this information is all collected, what am I missing here? What do they hope to do with this information? Like, what is it? Do we know how they hope to use it? Like, what changes that are supposed to happen with regards to this bill? Or is it just, we're just collecting data to have it?
You know, I can't speak to that. I don't know. Unfortunately, I can't speak to the intent of the legislation. I think it's a fair question, but you know, I don't think it's fair of me to answer it.
Right, I understand. That's kind of what I was going through as I was reading it, and I just couldn't figure out, you know.
Yeah. Okay, well, I don't see any other, Delegate Bartlett, I see your hand raised. Delegate Bartlett, would you like to go ahead?
Thank you. I just wanted to say, usually when we want a data collection bill, it's basically so that we can see our proposed legislation can be evidence-based. So you want to know, as opposed to being anecdotal. You know, I'm not saying that is the situation here, but I'm just saying generally when we want those types of data bills, that's what we're looking for, because maybe we've got constituents or people coming in and testifying and saying X, Y, and Z. And so now we need to be able to actually show that whatever we've heard is actually the case. And then sometimes we find that based on the data or based on the reports, there is need for change. And so we use those reports to make a determination on proposed bills for change. I will say the first thing I thought when I saw this bill was, what I really want to know the origin. I really want to know the impetus. I want to know why the sentencing commission is included, because it is a huge list. It's a huge list, and perhaps there could be some, you know, we put in amendments all the time, and so perhaps there could be some consideration of amendment to create a pilot program. You know, so we do that sometimes when we just take a small chunk to find out some of this information. And maybe we only, you know, say, you know, I can't think of a number now because, you know, like the rest of us, I don't know the IT stuff. But if there's a manageable chunk that we could take with the folks that we already have present and see if it's even doable. A small chunk, of course. Like I was thinking 50, but I don't know if 50 is just too small. But anyway, that's a possibility, because I am hearing that it would be good to have some of this information. So maybe, especially with Senator Sidnor being on the commission, maybe he'd be willing to, you know, to kind of talk about some tweaks and something that could be doable. So that's all I have, but thank you for listening.
Absolutely. Okay, I don't see any other comments or hands raised at this point.
So,
Dave, sorry, Dave, can I say something? I don't know how to raise my little
Yeah, go ahead, Brian.
I was raising a real hand, but I probably wasn't on the screen. I just want to, you know, as a social scientist, I'm all for data collection and data analysis. And I think there's lots of benefit to it in terms of, you know, lots of kinds of policy questions can be informed by better data, whether looking into racial disparities or, you know, the role of guilty pleas and plea bargains and punishment outcomes or bail reform or what have. So, you know, I'm probably on the commission, maybe one of the people who would be most in favor of data collection, but I'm not in favor of this bill because it fundamentally, getting back to something Judge Avery said, right? It fundamentally changes the scope of the commission's mission and the scope of the commission's work. And it doesn't seem to me that the Sentencing Commission is the right entity to be charged with collecting all of the data on prosecution and bail and having the responsibility of producing reports on things that don't really fall under the purview of the commission. So, you know, from my perspective, I would say data collection is great, but this bill and what it's asking the commission to do doesn't make a lot of sense. You need a different entity to be responsible. So that would be my recommendation for what the commission should be. You know, even if there's support for data collection, we're not the right entity to be tasked with such an immense task when it comes to everything that they're asking for here. Thanks.
Right. I appreciate that input, Brian. Yeah. I would, you know, again, I don't want to say like, maybe we can get Senator Sidner to share his thoughts on that, on why it was changed from last year to be, because last year it was GOCAP or Governor's Office of Crime Prevention Victim Youth Services, whatever we're calling that now, acronym. For reasons that I don't clearly know, other than maybe getting at what Judge Avery was saying, that, you know, he thought it would be better to have an independent commission perhaps being charged with collecting and analyzing the data. But is it consistent with the Sentencing Commission's enabling legislation? I think is a fair question. So Judge Avery, the other thing before if we get to a vote or whatever on it, did you want to, I know Judge Wilson had shared his thoughts. I don't know if you wanted to.
Yeah. Well, that's actually what I wanted to add,
Okay.
just real quick, because Judge Wilson wasn't able to make the meeting, but he did say expressly that consistency would require the same position on this bill that we took on the judicial transparency bill, which is an opposition. And he further stated that monitoring state's attorneys is beyond the scope of the Sentencing Commission. So that's his feeling about this bill, and I concur with that. I think we should probably just at this point entertain a motion if someone wants to make a motion at this time.
I would so move.
And that would be a motion to oppose.
A motion to oppose and adopt the position that you just described.
Okay. And the position would be drafted by Dr. Soule and approved by the chair, as well as circulated to the sentencing guidelines subcommittee. Is that's the protocol, right, David?
That is the protocol, right? So we're looking
Okay.
for a vote this evening about which position, and then the staff would work on establishing that and circulating it through, getting feedback from the subcommittee and chair to, you know, finalize the statement. We would then obviously share it with the full commission, but so we're working with a smaller group to. We also have a tight time frame because the meeting is, you know, 1 week from today, the hearings.
Okay. Is there a second to the motion by Mr. Fincy?
Okay. Yeah, we have a second.
All right. So all in favor of the motion to oppose Senate Bill 763, please indicate by raising your hand so that David can see.
Okay. Hold on. Delegate Bartlett, I see your abstention in the comments. I assume Delegate Moon is saying he already said it was. And Casey, I I know you've said that the OAG will abstain. Sorry, sometimes Melinda, is your hand up? It's sorry. Okay, thank you. I apologize. The way the window's it. It's okay. I think I got that. And then, okay. I think I got everyone. Were there any votes again? I think that it looks
Okay,
like that
so-
will carry, but are there any votes opposed? Mr. Zaremba, did you abstain? Okay. Yeah, you're on mute. I can't.
Yes, I abstain. I put it in the chat.
Oh, okay.
Didn't
I
write my name.
apologize.
Yeah.
I apologize. I didn't see that, and I see Secretary Greens as well. Okay, I apologize for that.
Okay, David,
Okay,
I'm
so
going
the
to give you,
motion,
yeah,
the
I'll give you a
motion,
minute. Go ahead.
the motion carries.
All right. Well, listen, thank you to everyone who came to this meeting tonight. And it's tough during the legislative session. I mean, the past couple of years, there have been a number of bills that directly impact this commission, and it does require us to review. And so thank you very much for taking the time out of your evening to join and pay attention to this bill and read it and show up for the meeting. So thank you very much. David, is there anything else?
No, that'll be it. But I do want to just echo those things, those same points, and thank everyone for taking time out of your schedule. I know we've been scheduling these on short notice of late, so I really appreciate everyone's prompt responses to the surveys and everything. It's a lot to get the group together, so I appreciate everyone's prompt attention to those and taking time out of your busy schedule. So thank you again.
Thanks so much. Good night.
All right, take care. Good night.
Good night, all.